I didn't hear the concerns of Honorable Taylor. Maybe I missed, but I didn't hear you respond to specific issues that he put to you. Now, the Attorney General was here and clarified to us and said we must pay attention to clause 2, because clause 2 in the bill is the scope of the bill. Because once you miss, according to him, once you miss clause 2, then you'll meander a lot. You'll meander a lot with a thinking that this bill, for example, is targeting everyone in the manner that has been discussed by some people. So according to the Attorney General, what he told us, this bill excludes, for example, NGOs in charity, in churches, excludes churches, investment companies, banks, multilateral organizations, family remittances, private remittances, law firms, business ventures. All those, according to the Attorney General, are out of the purview of this bill. So, clause 2, Honorable Taylor was engaging your indulgence on whether, in the event that he entirely rejecting the bill is not one of the options in the committee, how do you help the committee for us to be able to deal with clause 2? Because clause 2 also can be trimmed further for clarity. I'll give an example. You have just talked about government policy. Shouldn't citizens oppose government policy? Yes, citizens can oppose government policy. But if you oppose government policy for the interests of a foreigner, we cannot allow that. Why? Uganda decides, for example, to say we are going to do irrigation using the waters of the Nile. And you know some countries have interest in the waters of the Nile. Uganda wouldn't, for example, want Uganda to utilize that water such that it can be able to flow to the Mediterranean. So, a country downstream, for example, funds against such a policy of widespread irrigation. So, these people who are opposing that government policy, because they have been funded by a country downstream, for example, would be promoting interests of a foreigner. So they are within the ambit of clause 2. But ordinary opposition of, organic opposition of Ugandans going about their work and opposing government policy or laws, that one is not within clause 2. So I think myself, that whereas government seems to be interested in talking of adverse foreign policy, it is vulgarized. For example, the definition of foreign policy, foreign interest, is not so clear. So it is vulgarized. It could easily spill into even foreign policy which is friendly to Uganda. For example, an international NGO that is funding charity work, helping school fees to PWD children, vulnerable children. That one is friendly. Foreign interest, but friendly. The other one was subversive. It's not so clear in the bill, and I think we need to help the move of the bill, if that is his interest, because that seems to be the interest, that subversive foreign interest is what they are talking about, not just foreign interest, and it was not clear. So we need to be helped that in the event that the option of throwing out the bill entirely is not there, how do we trim clause 2 to ensure that there is precision and clarity on what exactly we are talking about? Yeah.
The Honorable Baka Stephen Mugabi, chairperson of the Legal and Parliament, remarks. Those remarks have worried me because he's a co-chair of this committee. He seems to have taken a decision already, and so our presence here is irrelevant.
As a Ugandan.
That's very worrying.
Not as chair, but
no,
as
but
a Ugandan.
You see, as a chair, with due respect, you are supposed to be a neutral arbiter, because now you're intimidating all these people who have come to make presentations, because they want to make a presentation in opposition to the statement you have said. But now the judge is already passing judgment and saying we cannot allow that. I want to request that we remain neutral so that these people can share their views. Otherwise, when you pass judgment already, we can very well pack up our bags and go away because you're just ticking a box. Also because, Honorable Baka, you see, clause 2A, 22A, says engaging in the political activities in Uganda for or in the interest of a foreigner. And then clause 1B, a Ugandan citizen residing outside of Uganda is a foreigner. But those Ugandan citizens, they remit 2.5 billion US dollars per year to their country. They come back home every so often. They've got business interests. They've got children they're paying school fees for. So if government passes an education policy, why don't you want them to oppose it? Because they're interested stakeholders. Their children are going to school here in Uganda. And so we should be concerned and capture all of these issues. Finally, again, Honorable Baka has said, in the event that throwing the bill out is not an option, why isn't it an option? Why are you ruling it out, Honorable Chair? Because this committee is clothed with all of those powers. Committees have thrown out business of government several times. In fact, even today on the order paper, there are some which are meant to be withdrawn. So there is room for that. Kindly don't create an impression that this bill is a do or die. It has got to pass. You have got the authority. Just to remind you, you're a senior lawyer, you know, as a committee of parliament, this bill is really at the whims and fancies of this committee. This committee can choose to say, government, we don't agree with this bill. We have thrown it out. Except if you want to say you are on gunpoint. I don't believe you are. I don't believe you are. So please don't make a statement to say that in the event that throwing the bill out is not an option. Let's give our views, and then the committee members will decide. What if they vote overwhelmingly to say let's throw it out?
Honorable, I think you, so with due respect, you meant to misconstrue Honorable Baka's statement.
Yeah, that's why
the reason for our being here is that we are open to receiving all the views. Please, yeah.
Okay. Most obliged. So I just, because as a colleague we can share, to say, these people here who don't know how to operate, they might think now it is finito.
Right, Honorable Lop.
It is
you know how we do our prayers in court. In the alternative, was you pray, these election petitions, but in the alternative,
yeah, but you see, as a petitioner in court, you can choose to say, for me, this is my only prayer. And then court decides. So court should not say, no, you cannot have just one prayer, but I'm the one coming to court, so I can choose to have just one prayer. I thank you, Honorable Chairs and colleagues.
Let me make a comment. Thank you. I think we applaud the...
Eunice Otukapio. I'm a member of parliament. I represent the people of Oyam County North. But today I lead a delegation of Lango people, a cross-section of people from Lango, who entrusted me a few days ago with a declaration to be read before you, Honorable Chair, and the co-chair and your members. I'm here as well as a potential foreigner, Honorable Chair, and as a potential agent of a foreigner, because I am a researcher with links to foreign publishers and with links to universities as well. And I'm also a member of a family that is quite extensive, with members living abroad. So I'm a potential foreigner and an agent of a foreigner as well. Honorable Chair and co-chair, allow me quickly underscore 3 statements that serve or that will serve as a context or the context to the declaration of rejection of this sovereignty bill by the Lango people. A cross-section of people living in the Lango, including myself, Honorable Chair, are highlighting a potential constitutional tension between the bill's combined provisions, and especially Articles 9 to 15 on citizenship. The combined provisions of the bill clashing with Articles 9 to 15 on citizenship, particularly where statutory classification will affect the practical enjoyment of these rights and freedoms, Honorable Chair. And that is, or those are articles on citizenship which are protected. They are entrenched and can only be triggered by referendum as per Article 255 of the Constitution. I thought I could say that clearly. And these are the three statements that underscore the very brief declaration of the Lango people. One, that citizenship is a constitutionally protected status governed by Articles 9 to 15 as amended, and that these provisions establish the framework for citizenship and safeguard against arbitrary or indirect deprivation of that status. That where legislation produces effects that materially alter how citizenship is recognized or how citizenship-linked rights are exercised, it raises constitutional questions as to whether such legislation is indirectly undermining protected constitutional rights. Two, Honorable Chair, that it is a settled constitutional principle that Parliament cannot achieve indirectly through statutory definition or executive discretion what it cannot achieve directly without following the constitutional amendment procedure. That where a statute produces the practical effect of altering or restricting citizenship rights or their enjoyment, it may properly be subject to scrutiny as a potential disguised or indirect amendment of constitutional provisions. And finally, to underscore the context, Honorable Chair, that the combined effect of the bills, especially Clause 1, when read alongside the said articles of the Constitution, that is 9 to 15, will significantly alter the practical enjoyment of the constitutional provision on citizenship and political rights. Accordingly, Honorable Chair and members, these provisions require substantial revision to ensure clear definitions, appropriate safeguards, and careful constitutional scrutiny to ensure compliance with articles, especially 9 to 15 of the Constitution, and to avoid any indirect or de facto modification of protected citizenship and political participation rights. These statements, Honorable Chair, are stipulated on the document with the clerk. I now turn to the declaration, which is very brief, of the Lango people, and I'm happy to note that I'm accompanied by a cross-section of them. Some of them are seated behind. The declaration, which was passed on to me, Honorable Chair, on Monday, April 20th, 2026, in Lira City, northern Uganda. We, the people of the Lango sub-region, representing cultural leaders, religious leaders, civil society, academia, ICT innovators, content creators, farming communities, the business community, youth, students, and families, supported by the diaspora, express our unified rejection of the Protection of Sovereignty Bill 2026. While the stated objective of the bill is to guard against foreign interference, its provisions raise serious concerns about their impact on the economy, civil liberties, and the socio-economic fabric of northern Uganda and the country at large. Honorable Chair, the diaspora remains central to Lango's recovery and resilience. Clause 1 of the bill raises serious constitutional concerns by reclassifying Ugandans residing abroad as foreigners, potentially conflicting with Articles 9 to 15 and 17H of the Constitution. The bill further appears to seek, in effect, to amend or circumvent Articles 9 and 15 of the 1995 Constitution, as I earlier explained, an entrenched provision, honorable members. Any such amendment requires strict adherence to constitutional procedures, including a national referendum. The approximately 2.5 billion Ugandans, 2.5 billion shillings Ugandans send home annually sustains households, education, healthcare, and local investment. By introducing restrictive state controls, approval requirements, and potential criminal penalties on cross-border financial support, the bill risks severely disrupting these remittances, which are the lifeblood of many families. These inflows support construction, agriculture, and small businesses that employ large numbers of young people. Restricting them would have immediate and significant negative effects on local economies, particularly in Lango. Honorable Chair, members, religious and cultural institutions play a central role in community welfare. The bill raises several concerns. By reclassifying institutions that are supported by international partners of diaspora contributions as foreign agents. Clause 28 permits warrantless inspections of premises, which may include places of worship and private residences of religious leaders. They are unhappy with this provision. And then about financial exposure, there's high institutional penalties which could severely constrain faith-based schools and health facilities that provide a substantial portion of essential services. Honorable Chair, members, on the impact to the economy, creative economy, the Lango people are saying that the artists and creatives increasingly depend on global platforms and collaboration. The bill may expose individuals earning from international platforms or partnerships to classification as foreign agents alongside severe penalties, and that this creates uncertainty that may discourage innovation, limit income opportunities, and push creative talent out of the formal economy. Honorable Chair, the fiscal and economic implications. The bill introduces compliance requirements such as ministerial approvals for financial flows that may discourage foreign direct investment and private sector growth. A reduced tax base may in turn increase pressure on domestic taxpayers. Already they are suspicious given what transpired this week with taxes, with broader implications for economic instability or stability. They are calling for action, Honorable Chair and your members, that government considers withdrawing the Protection of Sovereignty Bill 2026 to allow for broader consultation and alignment with existing legal frameworks, and to the committees here and Parliament to carefully assess the constitutional, economic, and social implications of this bill and ensure that any legislation protects, not undermines the livelihoods and rights of citizens. They conclude by stating, Honorable Chair, that the Protection of Sovereignty Bill 2026 raises serious constitutional, economic, and governance concerns. In particular, its provisions may affect entrenched constitutional rights, including citizenship, and therefore require careful scrutiny in line with constitutional procedures. We affirm that any changes affecting entrenched provisions, especially Article 9 to 15, must follow the prescribed constitutional process, including a referendum. The people of Lango, Honorable Chair and members, call for a legislative approach that safeguards sovereignty while fully respecting constitutional rights, democratic principles, and the socio-economic well-being of all Ugandans, for God and my country. Thank you.
Thank you, Dr. Pio, on your own behalf, and then on behalf of...
We have a full house. We have well over 10 stakeholders.
Absolutely. More than that, actually.
We need to save as much time as possible and listen to them.
Yes.
Can I propose humbly that we suspend asking questions?
Okay.
We
receive
the stakeholders, and we can convene as a committee much later,
yes,
to discuss the wonderful proposals from the stakeholders.
I am persuaded who came here want to be listened to. And we are here to listen to you. So for cross-examination that can come late, because we should retain your contacts. If we have questions to ask, we'll send and we'll receive written submissions to that effect. Okay? So, Honorable Bill.
Thank you, Chair. I proposal.
Because you are from Lango?
No.
Oh, okay.
No. I'm proud, of course, to be from
Absolutely,
Lango.
yes.
And I want them to know that my legislative experience is that there are open traps that can be set by the Committee for the Public and Ugandans to fall into. One such is what he has proposed, and we are not here to sanitize. Parliament is not running anywhere. The way Fox has communicated, as if we have a tight deadline to meet. If Chair, you confirm that.
No. We, in our opening remarks, we said we are here to listen to every Ugandan.
Yes.
Both here and even those who are abroad.
I am experienced. I've been here. We have done with UPDF, I know. That's why I'm saying we are not going to hurry with them. We should cross-examine them because we need to defend the report on the floor. Even if I raise a minority, I need to defend it. Even when I'm from Lango, for example, I have a question I want to ask. So
No.
how do you then, as a member of the committee,
Let's give a chance to somebody who hasn't. Okay.
Yeah, thank you, Honorable Chair. Honorable Chair, there are some areas that even this witness can help us to do justice to this bill. Because actually dismissing them that we hold on until the end, and then eventually, if we are not given enough explanations, we call them back, is unfair. Let us not hurry. Let's listen
Honorable
to them.
Santa,
Let us interrogate
let me hear from you.
get the information.
Thank you, Chair. Chair,